Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about the Fatal Accidents Act. Cases that should have gone to the Supreme Court of Canada, but didn't. In Saskatchewan, there's legislation called the Fatal Accidents Act, and essentially it allows a mechanism for people to sue whose loved one's death is caused by the accidents and the accidental conduct of another individual. Patricia Stacey sued her husband's optometrist because he failed to recognize that he had a fatal cancer in his eye. This ultimately led to his death. And the question that was before the court in the case was whether or not the negligence on the part of the optometrist actually caused his death, or whether the negligence merely hastened his death along. According to the law, the definition of caused by in the Fatal Accidents Act and the definition of caused by that's generally understood in tort law is different. And this was the point of contention in the case, whether it was important for the definition to be different or whether it was important for the definition to be the same. The court ultimately determined that what Ms. Stacey was bringing was in fact an action in tort, not an action under the Fatal Accidents Act, and it dismissed her claim. And this raises important questions. If you can only sue in tort, and there are caps, of course, for wrongful deaths in Canada, then you might not be able to recover the true value of your loved one's life as far as what your loss is to your household, to your work, to your employment, to your future. And by contrast, the Fatal Accidents Act will only allow you an opportunity to sue if somebody directly causes the death rather than indirectly causes it by failing to recognize a risk that ultimately leads to their death, even if it takes several years. Recognizing that these two acts achieve a similar purpose, it would make sense that the legislation and the common law definition of caused by would be the same, but it seems that that's not the same way. And this is inconsistent with other ordinary meanings and statutory interpretation circumstances that the courts have found themselves in. This was an important question of statutory interpretation, an important question about statutory law and common law when it comes to wrongful death situations, and a way in which the Supreme Court of Canada could have helped to relieve some of the tension and grief that people are suffering from that caused them to make decisions about pursuing one avenue of claim that might then, as a result of the length of time those processes take, foreclose their other claims. Wouldn't more clarity in what you're supposed to do and what is meant by the legislation be important to have in these types of cases, not less clarity, especially because the people who are bringing these actions are grieving the loss of loved ones? The Supreme Court of Canada had an opportunity here to make the law a little bit more fair and accessible for the ordinary person and the person who is most affected by it. And unfortunately, they failed to recognize that opportunity in this case and to achieve an outcome by granting leave to the case. And it'll take another case involving a wrongful death before the Supreme Court of Canada will have the opportunity to consider these issues, and that's just unfortunate. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.